David or Gary or Fred, if you're listening, I'm not seeing it on the website as streaming yet. Could you please check it, or it might be that we're just a minute behind. It's still displaying I cannot load screen. Thank you. Streaming yet? We're up. Check it out. Okay, we're up. Cannot load screen. We are up now.
Okay, we are up.
Yes, I believe so.
Okay. Since we are now up on live stream, at this time I'm declaring the meeting of the State Board of Elections to be open. And for the record, I'm going to call the roll of the members. Mr. Hogan, are you present? Present. Ms. Howell, are you present?
Present.
Mr. Flynn, are you present? Here. Mr. Velp, are you present?
Present.
And the chair is present. I declare that as a quorum present for this meeting. Next item would be additions to the agenda. Does anyone have any additions to the agenda? We are going to, under Congressional 7, item number 4, we're going to discuss the things that are going on in the Congressional 7 counties with the local boards, how they're preparing so that everyone's aware of what's going on there. Are there any other additions to the agenda? Hearing none. For those who are listening, the board is now going to go in pursuant to the agenda. The board is now going into a closed session. Once we finish with closed session, we will come back into the open session. We have a number of items on our agenda, and the vast bulk of them are in the open session. At this time, so if you will go away, but we're coming back. So, at this time, the board will now consider whether to meet in closed session to consult with counsel to obtain legal advice and consult with staff on pending or potential litigation as permitted by Section 3305, B7, and 8 of the General Provisions article. Meeting in closed session will allow the members of the board to seek and obtain legal advice with the board counsel without waiver of the attorney-client privilege and obtain information from staff about pending or potential litigation. May I have a motion to meet in closed session?
This is PJ. So moved.
Second?
Second, Bill Bell.
Moved and seconded. All in favor? Aye.
Aye.
Opposed? None. The motion having passed, the board will meet in closed session in accordance with exemptions B7 and 8 of Section 3305 of the Opens Meeting Act. All board members and staff participants should have the closed board information for the dial-in there, and we'll dial back into the same number for the open session. At this time, I'm going to recess the open session.
we get one of the senior ones tasted. Yeah, next time I get those, I gotta like put it in for like 20 minutes and then put the sauce on top afterwards. That's how you do it. I mean, that's a sauce. So, one second.
Malcolm Fun called in.
PJ Hogan is on.
Linda Lamone's on.
Bill Valp is here.
Nikki Charleston's here.
Donna Duncan's here.
Mike's here. Who do we have so far?
This is Nikki. It sounded like all the board members but Kelly.
Okay.
And I didn't hear Andrea join, but Linda, Donna, and I are here.
Okay. So we're waiting on...
Kelly Howells is here.
Okay. That seems to everybody. I'll do just a quick... Mr. Hogan, are you present?
Yes.
Ms. Howells, are you present?
Yes.
Mr. Fun, are you present? Yes. And Mr. Velp, are you present?
Present.
And I declare that we have a quorum for the continuation of the open meeting. At this time, the board will take up agenda item number 4. And 4A is written determination authorized under Section 4 of Governor's Proclamation. Before we open that up, Nikki, have we received anything from the Department of Health yet?
Let me check. No.
Okay. All right. With that, would anyone have any comments about this item? Open the floor. Okay. Unusual for this
I'm
group.
sorry. Mr. Chairman, I'm sorry. Maybe I didn't understand the question.
Oh, I was just opening the floor.
Right. So you're asking, with respect to the governor's proclamation, latest proclamation, item 4, special general election, and the question being, the state board may solely utilize as an alternate voting system voting by mail after issuing and transmitting to the governor's office a written determination. I'm not going to read them, A and B, we can go through them. That's what we're considering right now, right?
That is correct.
And how do you want to proceed? Answering A and B, and then are we going to vote on whether the April 28th special general election for Congressional District 7 is vote by mail only, or vote by mail with voting centers?
I'm inclined towards opening the floor for discussion of items A and B. That any given member may want to comment about both of them sort of sequentially rather than, or at the same time rather than separate in time. And of course, any member, we can come back anytime before a final resolution for a member to make any comments or observations they want to make. And then we would see whether there is a motion to vote to make those determinations. And if there is, what the vote is. If there is no motion, then the item would fail to go to a vote. There would be no determination because there would have been no motion. Council, is that generally what you would understand the process to be?
I think that's an appropriate process, Mr. Chairman. I think that the board does need to issue and transmit the written determination. So as I understand it, you're suggesting that the board vote on whether to prepare the written determination and then issue and transmit it. There may be required, there may be required a board vote actually approving the written transmission, unless there is direction to the staff to prepare a written transmission along the lines of the the evidentiary support articulated in this meeting and potentially prior meetings, to transmit to the governor, and have to look at it, but that may be a way of proceeding.
Mr. Chairman, if I could ask Andrea there, this is Bill Bell. Isn't it true that if our move is to either not make a move or vote to have at least one voting center per county, then there would be nothing transmitted to the governor because we would be using 3. Is that correct?
That's correct. The status quo, the default right now is that there shall be at least one voting center in each county for the April 28th election. The board may vote to authorize that, but it doesn't need to. That's what the law is pursuant to the governor's proclamation right now.
Thank you.
And with that, the floor is open.
This is PJ Hogan. I'll start off with that understanding that was just described, what the default is. Let me first say that, and this is not meant to be gratuitous, it's just meant to be factual. I think the governor of Maryland has handled this pandemic better than any governor in the country. He has been forthright in his directions about social distancing, sheltering in place, closing certain things, delaying the primary election, statewide primary election, until June 2nd. That's my opinion. Some facts. The Institute for Health Metrics and Evaluation, which has been an ongoing data source that many have pointed to as they collect data and make projections about the number of hospital beds needed, the number of cases of COVID-19, the number of deaths projected in total and each day, both on a national level as well as an individual state level. Maryland is projected to reach 0 deaths per day at this point, right now, as we're sitting here, not until May 10th. There will be many, many deaths per day in every day between now and May 10th under those projections. Our own Johns Hopkins University, in their data collection, currently ranks Maryland 12th in the country for total hospitalizations of COVID-19. That is regardless of the size of the state. That is just sheer numbers. As I look at both A and B, let me start with A. A asks that we substantiate the findings that it is not possible to utilize voting centers in a manner that mitigates and reduces a substantial threat to public safety or health posed by COVID-19. I consider a substantial threat to public safety or health as, in my opinion, anyone would contract COVID-19. I think April 28th is still too much in the middle of the pandemic, and the possibility of contracting COVID-19 remains high. We have heard from local boards of elections that they believe they will have a very difficult time staffing an in-person voting center. We were advised, I believe on our April 2nd meeting conference call by Dr. Mitchell of the Maryland Department of Health that the Maryland Department of Health could not guarantee access to personal protection equipment for poll workers at these voting centers.
Mr. Hogan,
yes.
This is the chair. I apologize for cutting you off, but given the direction that your thinking is going, we have some other information that I became aware of actually just shortly before the meeting, and I had intended that Nikki presented during the meeting. On reflection, I think she should present it now, and this will give a little bit more information about the local boards and where they're at right now. The 3 and congressional 7. Nikki? Are you okay with that? Nikki? Eddie?
Can you hear me now?
Yes.
Yeah.
Sorry, I couldn't. Anyway, technical problem. So yes, I'm happy to provide a quick update on the CD7, the Congressional District 7 special general election. I'm happy to report that the ballots were mailed last Wednesday. About almost 500,000 ballots were mailed out. Although that you all had previously authorized the local boards to start canvassing on the 16th, which was this Thursday, it seems likely that all 3 counties are going to defer until next week. We were able to order them masks, gloves, and hand sanitizer for the canvass, but we couldn't get them quickly enough for them to start this week. It's obviously, as you can imagine, a very challenging purchase right now, and I'd like to commend Shelley and Whitney of our budget and procurement team for finding some and getting some as quickly as they could. And also the county, the 3 local boards don't think that there's probably enough ballots that will be returned by Thursday to start on Thursday, but predominantly because of the delay in obtaining gloves, masks, and hand sanitizer. Each of the 3 local boards have a plan to live stream their canvasses so the public can observe. The local board members are getting sworn in this week. At least one of them is going to be done remotely. The local board members and council plan to participate in the canvass remotely, which is one of the regulations that's before you and that you previously approved for the June 2nd election. We'd also like that to apply to the April election. We are moving some equipment from one local board to our central warehouse so they can free up some space to do this larger canvass. And we've ordered ballot drop-off containers for their offices so that voters can drop off voted ballots at their offices once those containers are there. And that's my update. I can answer any other questions that you have, or if anybody else is on the line to add something that I've neglected to say, feel free.
Nikki, this is Mike. When you said you had obtained masks, gloves, and hand sanitizer, I believe is what you specified. You noted that we were only able to obtain a limited amount. From the context, I believe your indication is that that's all going to go into the canvas. Is that right?
That's correct. The request was to order for what they needed to get through the canvas. I do believe that, we got whatever we could. So if we had said if there's any extra that they should hold on to that for June, but the request was made at the time to support their canvas.
Okay. All right. Thank you. All right. PK, again, I apologize for cutting in. I just wanted to make sure that information was out there for everybody to hear as they were reflecting on your comments. And please, with my apologies, continue with your thoughts.
Thank you. No, that's fine. I believe I've said everything I wanted to say about A. As far as B goes, conducting the special general election without voting centers will comply with the constitutions of Maryland and the United States and any other federal law. This is a difficult thing to determine because ultimately only courts will determine this. But under the following factors, I, as a member of the State Board of Elections, feel that I can make that. I can personally determine that based on the following factors: that anyone can register to vote and be mailed a ballot if they register by April 21st. Is that correct, Nikki or Linda?
That's correct.
Also, any voter can ask for assistance in completing and mailing their ballot, and those ballots come with a form that is signed by the person providing the assistance. That's correct?
Yes, that's correct.
And any disabled voter can request an online ballot and use the online ballot marking tool with or without assistance. Is that correct?
That's correct.
With those three conditions, and given the severity of the pandemic, I personally believe that we can conduct a special general election without voting centers and do our best to comply with the Constitution and all federal law. Mr. Chairman, I'm finished.
Thank you, PJ. Any other member?
I'd like to second that motion. Malcolm Fun.
Okay. Any other member?
This is Bill Bell. I am having problems with the B. While I agree in principle with both Malcolm and, of course, PJ, Mr. Hogan, with what is open out there currently in essential businesses, I would currently vote, and again, I'm on the fence, so I'm very open to listening to what both the chair and Kelly also have to say, but right now I am for one voting center per county for that one day, and that we push through social media and however else we're going to get out there, that to only use the center if you need to. If you need assistance, or if you think you should have received a ballot and did not. One of the played out reasons, I know we can't stop people from coming there, but we would, under that scenario, kind of like we're having things delivered now for the most part from a grocery store, but sometimes you're going to the grocery store or whatever. That would be the way I'm leaning today. I think I heard 2 of the 3 municipalities already have a place they can use. I just heard testimony that there might be availability of some PPE. That's how I'm leaning right now. Thank you.
Ms. House?
Yeah, I was in favor of opening the voting centers at the March 25th meeting, and my opinion really hasn't changed in the last couple of weeks. This is a special election. Historically, there's not a lot of interest. Every registered voter in the congressional district is going to receive an absentee ballot and a postage paid return envelope. That is how most people are going to vote. Most of the registered voters who get their ballot that way are under a stay-at-home order today and may very well still be on April 28th. What we have now that's different from March 25th is now we have an instruction from the governor to open up the voting centers. It's one in each county. And our option for not doing that is that we have to substantiate our findings that we cannot do this in a way that mitigates and reduces a substantial threat. And I point again to the grocery stores. They can operate with their procedures for mitigating the threat. limiting the number of people in the building, asking them to move certain directions down aisles, asking people to wear courtesy masks. There are all kinds of things that can be done to operate a grocery store that substantially reduces the risk. And the number of voters who are going to need these voting centers is so small. And yet for them, the voting center is such a big deal. It allows them to vote when they otherwise could not vote. And so I feel the same way I did March 25th. Even now I feel stronger that we should do this because it isn't just us anymore. Now we've got an order from the governor to do this unless we can substantiate our findings that we can't. And I don't find that we can't do it.
Okay, thank you. I certainly have my own thoughts about this, and I know for myself with certainty, and I know as to my colleagues on this board that thoughts about the decisions that we're making during the pandemic are never far from their consciousness. In addition to the constant things that arise that cause us to come together, there's not one of us that isn't aware of the human toll in all of this. So the first point I would make for myself, for my perspective, is that we're not talking about the right to vote per se. We're talking about the availability of various modes of voting. And I think there's a critical distinction there to be made. And in many ways, I'm happy that the board, that all the members have spoken and provided their reasoning, because I think it's important that people in other states during this pandemic or at some time in the future will be able to come back and say, well, why did they do what they did? And I think it needs to be clear what our thinking was. The infection, which is the Proclamation 4A section, can we mitigate? What do we know now? And we know from back on March 25th it's going to be infectious. We know that there was a possibility of infections, even probability, I believe, was brought up at the meeting, and from that the possibility of deaths. We were told then, given a somewhat different date of peaking, that peaking period has been moved back into April now. The thing is that peaking is not a cliff on the other side. It's a slope up and it's a slope down. We know that there's better treatment modalities available than there were on March 25th, which gives a sense of how fast all this moves. The issue, and I believe that this board is capable, even without the presence of the health department today, of using the information available to it from various meetings and well-known public sources to make a determination that we really can't preclude the possibility of infection in the voting center. Can we mitigate it? Sure. I mean, a local board could allow one person an hour come into the voting center. That would mitigate it. But my concern is on 4B. Because 4B, and I believe one of the things that I heard a long time ago was that the choice of words in legal documents was very, very important. That they were presumed not to be put in willy-nilly or casually or just, for whatever reason. That there was a real sense of the word means what it says. And one of the things that this proclamation says is that the state board must determine, in written determination, state that conducting the special journal without voting centers will comply with other federal law. And I don't read that as meaning that we could eventually be vindicated. If that were the case, I would expect to see words to the extent practicable, something like that. That's not in there. The proclamation specifically says that we're certifying, we're stating in our determination, we have determined that we will comply with all federal laws. There are many times in the law when the law is not complied with. And when that happens, it goes up to a court, and the court may in fact vindicate the person who didn't comply and say, under those circumstances, we're not going to hold that. That there's something wrong here. We're going to say that, in fact, yeah, you didn't comply, but, and then we'll go on to list whatever the circumstances are that caused them to waive that particular transgression. And so, if we were in a court at this moment, that court may well find that a determination by the board in fact was based on the fact that we were in the middle of a national and Maryland state of emergency in which we virtually shut down our economy, in which people are dying, vast tracts of the population are becoming infected, and that there might be a reason not to put something out there which will attract potentially large numbers of people, which is one of the local board's concerns. We don't know what the turnout will be. We don't know how many people will go to one of these centers. This is the core issue in my mind. And it's a core issue because I'm going on the basis of what I don't know Convention asked for. And not what's practicable. So, one of the things that I would remind everybody of, not my colleagues, everybody but my colleagues and our professional staff at the state level, our counsel, who have been with us through this entire process. It is a fine thing to advocate for things under the law. It is a fine thing to say that this individual or that individual may suffer a harm to their constitutional rights, to their ability to carry out certain things. It's not really what this board has looked at. Because the question then becomes, how many deaths what's the upper limit on deaths for you to have this particular mode of voting? How many people can we afford to lose for you to have this mode of voting? And so for those who look back at the record, that's been our key concern. What's the upper limit on deaths? But that's not what we were asked to determine. We were asked to state that we're complying with law, not to the extent practicable, not that we expect to be vindicated in court, not that based on the whole first thing, 4A, we're making the point that there's a pandemic that's out there killing people. No. 4B says comply with the law. And because that's what it says, I believe I have no choice, none, however I personally feel about this, to make a statement that I know to be false. And it hurts. So, with that, question, I think, does anyone else have any other member have anything they'd like to add? Hearing nothing. At this point, I believe that the question would be, as counsel counseled me earlier, to first determine what the board's position is on this. And I think that would probably be best determined by a motion to present a written determination to the governor under the provisions of the proclamation 4A and 4B. Because the only written determination we would submit, as counsel has told us, is the written determination that there is a serious problem, that we really can't do much with it to keep people from being harmed, and that we comply with all federal laws. So, the question, therefore, I believe, and counsel, you can speak up and tell me if I'm off the parliamentary track here. The chair would entertain a motion to submit a determination to the governor pursuant to the provisions of the proclamation 4A and 4B. Is there such a motion?
Sorry, hearing no one was on mute. Sorry, Mr. Chairman, I was on mute. This is PJ Hogan. I'm going to go ahead and make the motion that we can meet A and B.
Okay, the motion to submit a determination has been made. Is there a second?
Malcolm Fun, I'll second that.
Okay, made and seconded. I don't believe there's a necessity for further discussion unless any member wishes to do so. Hearing none, we'll move to a vote. The vote will be by roll call. Mr. Bell, your vote. I'm sorry, I didn't hear.
Nay.
Nay. Mr. Fun, your vote.
Aye.
Mrs. Howell, your vote.
Nay.
Mr. Hogan, your vote.
Yes.
And given the nature of the vote, at this point, the chair will simply abstain. 220, 221, that would fail, the motion would fail, and the board will not submit a written determination. Next item, Nikki, 4B, emergency changes to COMAR.
Okay, thank you. So I apologize. There's the descriptions I misaligned, so I will go through them very carefully, and there's one reference to COMAR that's incorrect. So we'll start with 330801. You received in your board meeting materials each of these, so this is the first page of that Word document. So this is to allow for the canvass to vote without the local board members themselves being present for the entire time. This requires that the board members are present at the opening of the canvass, the closing of the canvass, and at scheduled times when they make for decisions. This is something that we talked about in drafting the comprehensive plan for the June 2nd election, and we were advised by council that we should turn these into emergency regulations, and that's what I have before you. So 33080102 allows that the local board, requires that the local board members be present only during when the canvass starts, when it ends, and when there are decision sessions. And we have separately advised that that presence needs to be remote, and the local boards are doing that. But this would just be an emergency regulation just in place for April and June.
Okay.
Well, my good question. There's nothing in here, Nikki, to use, and I'm not reading it like there is, so I'm not proposing change. But there's nothing in here that would preclude a board member from being present virtually through the whole process if they wish. They would just have to be there for those 3 times. Is that correct?
So what we're advising is that they should be virtual all the time. They should never be in the building. So present means virtually in this case, but that they only need to be virtually present in those 3 times, those 3 circumstances: opening, closing, and when they schedule decision meetings.
But they could be, and it would be available for them to be present via online for the whole process if they chose.
Oh, yes. I'm sorry. Yes. They could do that if they wished.
Yeah, that's the way I'm reading this too. So I'm good with that.
So, other questions or discussion? Board will entertain a motion to approve the emergency change to Kumar 33080102.
This is PJ. So moved.
So moved. Oh, second, this is Kelly.
Moved and seconded. All in favor? Aye.
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 Aye. Opposed? Hearing none. The ayes have it. The emergency change is made. Item 4C. Nikki?
Thank you. So I'm going to do these individually because this is where I have a typo. So 331104, 05, and 07 are changes to adopt something that you all have already decided in adopting the comprehensive plan for the June 2nd election. It allows for an individual to do the signature check on vote by mail ballots and the timeliness check on vote by mail ballots, and review to make sure, identify whether the ballot can be scanned. The current regulations require that that be done by a team. We discussed that in terms of the June 2nd election, that it would be okay for it to be done by one person to speed it along and to allow for there to be more ballots being canvassed at the same time under the CDC guidelines of social distancing and limiting to groups of fewer than 10. So the changes to 33110405 and 07 make that change from a team to an individual.
Nikki, would all, and this is Bill Valve again, is there, and I've read through it, what concerns me is just that we have video or we have online, not just of the area but for the watchers to watch this process if they want to. What are we doing so that somebody can watch them open up ballots like that?
So each of the counties is working to put in place a live streaming for the room, as well as live streaming for the board table. So when the board members are virtually present and discussing referred ballots, discussion be heard. But there is also going to be a wider view of live streaming for the room or rooms in which these activities are taking place.
And so what happens if that live streaming is not going?
You mean it just stopped functioning?
Either that or a particular out of our 20-some jurisdictions, one of them doesn't get it working that day. Like if we didn't get our audio working, we don't meet. I'm worried about the view of transparency. See what I'm saying?
Sure. So I think for the 428 election, the three boards have a good plan in place, and they plan to test it when they do their public demonstration. That's required under regulation. They're going to use that same live streaming functionality during the public demo. And we are working with the other 24 counties to put something in place, however that works. But to your point, I think if there's no live streaming available, then they'll have, if it stops, they'll have to stop until they can get that resolved, and I think they understand that.
Yeah, and I'd almost be willing to put in a motion that gives them, maybe not in Comar, I understand, but where the board gives them direction that they can't conduct the canvass if there's not transparency through live stream to the board and to the public. Thank you.
Okay. Anyone else? Questions or comments? Okay. Then at this time, the chair would entertain a motion to approve the emergency changes to Comar 33, 11, 04, 05, and 07. May I have that motion?
So moved, but with the stipulation that administratively they would ensure that the live streaming would always be active
when they're working. Can be active when they're doing this stuff. Yeah. Okay.
It needs to be put in here under Comar.
Yeah.
They have a separate motion for that. How does that work?
Well, I'd say administratively, so it wouldn't be listed in the regulations itself, since these are emergency regulations.
Let me, and agree with Malcolm, just give me a distinction. Let me go to Nikki and Andrea for assistance on this. Do we make an amendment to the emergency regulation, which I think would be one way of doing it, amending what the staff has proposed, or do we have the authority, and I think we do, to simply issue an order as a separate item saying, if that's not working, then you have to stop what you're doing until you get it working again. Andrea, Nikki?
This is Nikki. So it would be a different section of regulations, and I don't know which section that would be. So if Andrea says it's fine for you to do just a board directive, that would be my preference.
Okay. Andrea?
Yeah, Mike, I can't answer that question right now. I think if it's a question of what the proper mechanism is to include that requirement or impose that requirement, I suspect if the board wishes, it can approve these regulations, and then the issue just becomes how to paper that other aspects that the board wishes to be included in it. That's the best that I can
Okay.
say. I just need to look into it.
Okay, Malcolm, well, actually everyone, but we have a meeting scheduled for the 22nd. It's one of our backup dates. And we have a couple other things that may need to be done also on the 22nd. So what I would suggest is we approve the regulations as presented by the staff. Andrea then can give us legal counsel as to whether we have to go back in and amend the emergency change or whether we can simply do a directive from the board, and we'll do that on the 22nd. And at the same time, I know that Nikki's going to send something out to the local boards anyway saying, look, this is what the board's going to want. It's just an administrative question question of where they're going to put it in the, how they're going to do it. Does that work?
Mr. Chairman, I believe that they're starting canvassing on the 16th.
Didn't they get postponed?
So they were planning to start on the 16th, but because we weren't able to get them sufficient safety supplies, the masks, the gloves, and the hand sanitizer, they're not starting until next week. I'm not sure what day next week, but they will not be starting this week.
Okay, well, the 22nd would be too late, so Bill's point is still well taken in terms of my proposed solution. We can think about, well, Andrea, how long would it take you to get back to us with this?
I'm actually looking right now, Mike, so I can do my best by the end of the meeting. How about that?
That's great. Your best is normally just terrific. So, all right. With that in mind, the state is going to defer on 4C until we get something back from council, and we'll move now to 4D as in Delta, and go through that one. Nikki?
Thank you. So this one is, Comart 33.21.05, that's where the mistake is, 0501. And so this is under the special election by mail provision. And it talks about that all of the procedures that are in place for early voting election day apply to a vote center. And that would require then that the local board staff, or the local board have staff on site at that vote center during opening and closing. And this proposed change, again, emergency just for the next two elections, would say that the local board staff does not have to be on site, but has to provide remote site. And what they're thinking about doing is doing it by FaceTime or some video conferencing so that they can provide the necessary support without having to be on site.
Okay, you say this is 331705.
It's 33210501.
Okay, because I'm looking at this document here and it's got chapter 06.
Right, the agenda does.
No, I'm looking at the document that was sent out, and it says
go to the page before. Page 4.
Oh.
It says 17. It should be 21.
Oh, okay. Okay.
It's page 4. I apologize. It's page 4, which is, it should be subtitle 21. It says 17 early voting, and it's election judges, local board employees. We require that generally that they'll be on site for opening and closing, but in the interest of limiting the number of people there and trying to limit the exposure to the local board staff, we'd like them to be able to provide remote support.
Okay. And because I'm trying to make sure the record's clear here, we're talking about 170501?
Well, 17 should be 21.
Okay, 210501.
1, yes, correct.
Okay. Okay. And that's on page 4 of the materials that were sent out to us.
Yes. Yes.
And I see that, I can see that it is. Board members, discussion? Questions? Hearing nothing, the chair would entertain a motion to approve emergency changes to Comar 210501.
So moved, this is Bill Bell.
Second?
Second, PJ Hogan.
Moved and seconded. All in favor? Aye.
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 Opposed? Hearing none. The emergency change is approved.
Okay, so then on page 5 of the packet is 33210601. So we currently have that there's, as you know, we have both an election day and a polling place evaluation program. And this provision says that there shall be an evaluation program for vote centers, and would like to temporarily repeal this provision for the next two elections. Many of the procedures that exist in that evaluation program aren't going to apply, that we will clearly be evaluating the vote centers, especially as you all decided for the April election, so that we can learn from it and apply it to the June election. But the evaluation program form does not include things like keeping distance, wiping things down. It doesn't include the things that we would want to evaluate. And so it would just temporarily repeal this provision for the April and the June elections.
Okay. Board members, discussion? Hearing none, the chair will entertain a motion to approve the emergency change to Comar 3321 0601. May I have a motion?
So moved, Michael Fund.
Seconded, Bill Bell.
Moved and seconded. All in favor, aye.
Aye.
Aye. Opposed? None. Motion carries, and the regulation is amended.
Thank you.
Okay. Okay. So 4C, we'll return back to that. Mickey, make sure I don't forget that. And we'll now move to item 5, presidential primary election, June 2nd, 2020. Mickey?
So as we requested that the board do for the April election, we are similarly asking for you all to extend the voter registration and related deadlines for the June 2nd election. The requested deadline is May 27th, which is a Wednesday. It's a slightly different schedule than for April because of the vote centers, and so the current deadline is the 12th, and we're asking to move it to the 27th, which is 15 days later, closer to the election, which we think will benefit voters and still enable us to get vote by mail ballots out, or either by mail or electronically.
All right. The discussion. Hearing none, the chair will entertain a motion to extend the voter registration and related deadlines in the presidential primary election June 2nd, 2020 to May 27, 2020. May I have that motion?
So moved, PJ Hogan.
Second?
Second, Kelly Howell.
Moved and seconded. All in favor? Aye.
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 Opposed? Motion carries.
I have a point of information, Mr. Chair, about this.
Sure.
We changed the deadline for the April election. Is that deadline that we set effective by now having early voting centers? Not early voting, sorry, but voting centers, Nikki?
So we talked about that, and I'm sorry, my dog just shook. We talked about that and think that the poll book team can still get the poll books ready with the current deadline, so no additional changes needed.
Thank you.
Good question, Bill. Moving to item number 6, presidential general election, November 3rd, 2020. Vicki?
I'm actually going to see if either Jared or Mary want to address this one.
Actually, I think Andrea.
Okay, Andrea.
I'm on the line for any questions too, by the way. So.
I'm happy to do it, and then Jared, you can fill in with any policy or technical issues that you can fill in. But there have been, I think, as the staff indicated in a recent meeting, there have been several requests for modifications to the current procedures regarding petitions in general. And one of those is a request for an extension of the deadline relating to the submission of petitions to support a amendment to a municipal or a county charter. That deadline is a statutory deadline. It currently falls, it's some number of days before the election. I think it currently falls on July 27th, I believe. And the request was for an extension of as many as 30 days. I don't recall exactly, but I know there's been some work done by the staff to determine what sort of extension would be possible. And I'll let Jared speak to that. But in terms of the authority that the board has to extend this deadline, on March 12th, the governor issued one of his emergency proclamations. It had a couple areas of focus. One of them was essentially delaying the expiration of licenses or permits or things of that nature that were set to expire within the period covered by the emergency declaration. But the other aspect of that order, one of the other aspects, was to allow agency heads with responsibility for administering statutes or rules to extend the deadlines provided by those statutes which they administer, if doing so would not harm the public health, and subject to the submission to the governor of that extension after 24 hours, after which then the extension would go into effect. In this case, the board does have the authority to extend this deadline for a manner that is deemed appropriate, for a period of time that would be deemed appropriate by the staff in order to be able to put the balance together and so on. One point of caution is that under the governor's March 12th order, the extension lasts until such time as the state of emergency is lifted, plus 30 days thereafter. And so the risk here would be a deadline is extended, but if the state of emergency is lifted essentially before the beginning of July, it could potentially have the effect of nullifying that extension automatically after the 30 days after the state of emergency is lifted, expires. So I don't think anybody on the phone now can predict what's going to happen in June and July and August as far as the state of emergency goes, but I just wanted to make the board aware of that. It was considering whether, under the authority granted by the March 12th proclamation by the governor, to extend this particular deadline. So with that, I'll let Jared fill in the rest of the blanks.
Jared?
Sure. So we propose moving back the deadline 1 week. It is the same deadline that candidates and new party petitions are all due. It still meets the verification timeline that we are required, and the same timeline for us to make sure that we can certify the ballot to meet the MOVE Act deadline necessary to comply with federal law on that. So with this, we can look at it and move it back just the 1 week, but we can't postpone it further than that because of the other statutory deadlines of both state and federal.
Okay. Board members, discussion?
Would there be some, let's say 30 days after the order is lifted, let's say it's lifted in June, we still need to give this extra time that we laid out based on that's what everybody's thinking now. And I guess this is a question for Andrea. Would we have to go and have the governor make a special proclamation for this date?
Bill, some further action would be needed by the governor if the state of emergency, if the board issues an extension, and to be clear, under the proclamation, there needs to be a finding, and there's a form that's provided in the governor's guidance that his office provided in connection with complying with this order, and I believe the board can vote and direct the staff to prepare that and potentially submit that then at a subsequent board meeting for approval. But setting that aside, if the board does authorize the submission of that finding, and it does authorize the extension, it goes into effect. And if the state of emergency is lifted, let's say June 15th, then effective July 15th, that suspension by the board would be nullified, and so some additional action would be required if the board still thought it was appropriate for the extension for the deadline falling on July 27th to be extended an additional week. And I believe at that point only the governor would have the authority to suspend that statute under a new declaration of emergency. And I'm not an expert on what specific authority the governor has. If the state of emergency is lifted, there may not be governor's authority to do that, but I can't answer that.
Well, that's actually a little scary. This is Phil Melp again, if you don't mind. If we move this date, there are people that are going to be relying on the date that it is moved to. And if the governor doesn't have authority outside of the emergency, and the emergency is lifted, I'm not sure that's fair. I don't know what anyone else thinks. I'm not sure how to go about that or what to do.
Well, this is Mike. I was thinking the same thing, that there's going to be reliance on certain dates. And I think the reality is that we have to do what we think is appropriate now. And then as it goes down, as it moves down the track, try to make changes, or ask the governor to make changes, or whatever may be appropriate. I mean, I don't think, if we don't change this, then people, will be working on one number, and then we could have changed it. Karen, how much of a change is this? And I apologize if I missed that along the way. What's the duration of this change?
So 1 week.
It's 1 week. Okay. It's Mike again. Do we think that the 1 week will make a significant difference? Bearing in mind it's out in late. Go ahead.
I don't think we're in the position to answer that. That would be more for the petitioners to answer that question. How they would get about. And so.
Fair point. So I think we have to do what we think is appropriate now. This is my own feeling. And if things change down the road, staff and council will come back to us and say, look, we have this problem, and then either we have to try to get the governor to do something, or there may be something within our authority, even in a non-emergency situation, to try to extend that. I'm not sure what choice we have, other than
we have a meeting on the 22nd. Couldn't we table this and get the information then? I mean, that's still months before the deadline.
Sure. I mean, I have no problem with that. Anybody have any other thoughts on it? Okay, Bill, you are moving to table until the next scheduled meeting.
Yeah, and see if our either staff or Andrea can get us information on how we can make it a permanent one-time move.
Okay.
How that would work, because I don't want to give a date and then come back and you take a week away from them. That's a lawsuit asking it to happen right there.
But your motion is to table until the next scheduled meeting.
It is.
Is there a second to that motion?
This is PJ, second.
Moved and seconded. Any further discussion? Hearing none, move to a vote. All in favor of tabling this particular agenda item to our next scheduled meeting, Aye.
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 Opposed? None. Motion to the agenda item is tabled to the next scheduled meeting. Okay. So, got a little problem here. There we go. The next item is old business. And I don't believe we can. Go ahead.
Nikki, I don't know if you want to go back to 4C now or...
Yeah, I was going to give Andrea another 60 or 120 seconds.
Okay.
I'm happy to report that the COMAR, Title 33, Subtitle 8, Chapter 1, Regulation 7, requires that throughout the canvass, all sessions, deliberations, and proceedings shall be open to the public and the media. And so I think there is a current requirement that if the open to the public is being satisfied by live streaming and in some cases audio access, then the absence of that or the failure of that to work is already in violation of an existing regulation, so that the local board can be instructed to cease the canvass until such time as that is fixed. Is that sufficient for the board to proceed on?
Isn't that similar to our need to live stream our meetings, and when the stream shuts down, we go into recess and start up again?
It is similar. There's a statutory obligation for the State Board of Elections to live stream its meetings. It's effectively, I don't see a difference. That's specific to live streaming. This is more general to public access in general, but if you're not providing access to the public via the live stream, then that regulation is not being complied with, and so they need to remedy that.
I think with that knowledge as it builds up, I think just a direction from the staff to make sure they're complying with that would be sufficient. In fact, I agree with you.
Well, in that case, I reinstate my motion.
Say again, Malcolm.
I move that we approve the change to COMAR, and I add with administrative direction that live streaming always be operative. But that's not necessary. We just go with the motion and what Andrea just mentioned. That automatically just take place, because if you didn't have the live streaming, you wouldn't have the public notice.
Okay. Is there a second to Malcolm's motion?
PJ, second.
Okay, moved and seconded. All in favor, and now we're on 4C. All in favor of the motion? Aye.
Aye.
Opposed? None. Motion carries, and the changes are approved. And Nikki, make an administrative note that should go out. You know, the feeling of the board, the sense of the board should go out to the, or let me put it this way, pointing out the statutory requirement to the local boards. Okay. Any other old business? Any new business? Any campaign contributions? The next meeting is currently scheduled for Wednesday, April the 22nd at 2 o'clock in the afternoon. Does anybody see any reason to move that? It may get canceled because we did these, you know, in anticipation we might need them. But does anybody see a reason to move it? No? Then the next meeting is scheduled for Wednesday, April 22nd at 2 o'clock in the afternoon. May I have a motion to adjourn the meeting?
So moved.
PJ, second. This is PJ.
Moved and seconded. All in favor of adjournment? Aye.
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 Opposed? None. This meeting is adjourned. Ladies and gentlemen, thank you very much.
Thank you to everybody.
Thank you, Mr. Chairman.
Thank you, Mr. Chairman, and thank you to the rest board members.
Thank you.
And thank the staff. And definitely thank Andrea.
Everybody stay safe.
All right.
Thank you.
You too.
Well, I'm on lockdown, so I have to.
Malcolm, you're too wily an individual. No lockdown can hold you. Everybody take care. Bye-bye.
Bye-bye.